On behalf of Cross Catholic Outreach, welcome to today's webinar. My name is Bill Fenton. I'm the Senior Director of Gift Planning for Cross Catholic Outreach, and I'll be the host of today's program. This is our third webinar on the topic of estate planning. Our focus today will be on revocable trusts, and I'll introduce our guest speaker, Maria Capritto, in a moment. Our first two estate planning seminars can be viewed for free at any time on our Cross Catholic Outreach Planned Giving main webpage. The direct link is crosscatholiclegacy.org. Scroll to the bottom of the page, and the first webinar is entitled How to Plan Your Will, also featuring Maria Capritto as our guest speaker and covering wills, probate, power of attorney, and other basic aspects of estate planning. The second webinar is entitled Financial Tools for Charitable Giving, featuring Dana Robinson, Chair of the National Catholic Community Foundation, as our guest speaker, and covering charitable gift annuities, donor-advised funds, and other charitable giving vehicles. Today's webinar, like the previous two webinars, will be recorded and will be available on our Planned Giving webpage at a later date. For today's webinar, featuring revocable trusts, our guest speaker is Maria Capritto. Maria is a partner in the law firm of Nelson, Comis, Kettle, and Kinney in Ventura, California. As a highly respected estate attorney and a certified specialist in estate planning, trust, and probate law, Maria has a lot to offer us. She is also a certified public accountant and has a master's degree in taxation, and we have benefited tremendously from her expertise in helping donors who have included Cross Catholic Outreach in their estate plans. Many of our donors who have been helping the poor through Cross Catholic Outreach have asked us how they can carry on that legacy of compassion and generosity through estate planning. And we rely on experts like Maria to help ensure that their questions are answered and their needs are met. For many, I might add, the process has been a wonderful time of self-examination and spiritual growth, much more than just a wise financial exercise. I'm always gratified to hear how valuable they say the experience has been. Several of you submitted questions when you registered for this webinar, and Maria will answer those questions regarding revocable trusts during her presentation. If time permits, after her presentation, she will answer other questions submitted during the registration process, as well as questions submitted during her presentation today, using the Q&A chat. You can submit those by tapping Q&A in the center of the bottom of the screen. A window will pop up, allowing you to type in and submit your question. And now, I welcome back and thank Maria Capritto for being with us today.
Thank you, Bill, for having me back. And I want to go over a topic that's near and dear to my heart because it's a very important planning tool. And the last thing you want to do is fail to plan. And so I'm going to be discussing revocable trusts. And basically, a revocable trust is a estate planning tool that allows for property management during your lifetime, and then a way to distribute your assets upon your death. Revocable trust is revocable by the person creating the trust, and that person is what's called a settlor. They can also be called a grantor. I'll use settlor mainly in my presentation. So unless the trust term specifically states that the trust is irrevocable, it will be a revocable trust. Now, the issue with an irrevocable trust, just to cover that, is that if you have an irrevocable trust, when you fund those assets into the trust, you basically have gifted those assets away and that creates gift and other tax consequences. So for basic estate planning, we do revocable trusts because we want the settlor to be able to revoke the trust and make changes to the trust as things occur and change during their lifetime. Next slide, please. So I'm going to go over the advantages and disadvantages of having a revocable trust. One of the main reasons people create revocable trusts is because they want to avoid probate upon their death. So when you create a trust and you transfer assets into the trust, the assets that are funded into the trust avoid probate when you die. The reason that's an advantage as well is because it avoids administrative costs, such as executor's fees, court fees, and attorney's fees that can add up. Here in California, the fees are based on the value of the assets subject to probate. So it's a percentage of the value of assets. So you can get up to fees of $10,000 to $15,000 for the attorney and the executor of your estate very quickly. So avoiding probate is an advantage of having your assets funded into the trust. The other thing that a trust does is it allows your trustee to act more quickly. Generally, the trustee has to wait for a death certificate to be issued. And then once that occurs, they can take charge of the trust and the assets held in the trust and start administering those assets, paying debts of the decedent, final funeral expenses, medical bills, anything that is outstanding and owing by the settlor. In a probate, you have to file a petition with the court, wait for the court to get a hearing on calendar. Here in Ventura, it could take 3 to 4 weeks because you have to give proper notice. In LA County, which is obviously our next closest, biggest county to where I am, it could take a couple months to get on calendar in a probate. So it is a lot faster when you have a trust for administration. And if everything's properly titled, you can get through trust administration in a year or less. Probate could take up to a year or longer. So that's another advantage of funding a trust and creating a revocable trust. And finally, one of the other biggest concerns I have for my clients, I tell them, is that it's a substitute for a conservatorship. Here in California, it's called a conservatorship. In other states, they're called a guardianship for adults. So if you have a conservatorship, it's a public process. Everyone gets to see and hear what's going on in your life. But if you have a trust and you become incapacitated, the successor trustee steps into your shoes and takes over for you as successor trustee. Now, in my trust documents, and generally most trust documents, should have a mechanism for defining and triggering when you are deemed to be incapacitated. In my documents, I state that the settlor must be examined by 2 licensed physicians and that they need to basically write a statement saying that the settlor can no longer manage their finances or they can no longer act as trustee. Now, recently in California, I used to be able to just create the statement, have the doctor sign it, and now the financial institutions are saying they want it on the doctor's letterhead, but not only do they want that statement on the doctor's letterhead, they want it to be under penalty of perjury. So I've now had to add a penalty of perjury statement and requested that the doctors basically take my statement, type it on their letterhead, and sign and date it. So with that document, the successor trustee can take over managing the assets of the trust. So the disadvantages, obviously, of having a trust is the initial cost. Creating a revocable trust is more than just creating a will. So that may deter some people, but the reality is that the cost of creating a trust is going to be much less expensive than going through a probate when you die. So you may have to pay a little more now, but in the end, it will save the estate in your estate money. The other thing you have to consider is that there are costs to fund the trust. And what I mean by that is if you have real estate, those assets need to be transferred into the trust. So there'll be deeds, there'll be recording costs, things of that nature. Trust formalities have to be observed, which it's the time and effort of you, once the trust is created, to go to the bank or your brokerage accounts, wherever you have investments in money, and you have to actually transfer title to those accounts into the name of the trust. So that's, and it should be, it's time consuming, believe me, when you have to go to several financial institutions and it's repetitive. But in order for those assets to avoid probate, they have to be titled in the name of the trust. Now, when you as a settlor are acting as trustee, there's no fees involved. But if you have someone else acting as trustee, whether it's, a family member, a friend, professional fiduciary, a bank, then they are entitled to receive trustee fees. And so that's an additional cost for the trust. And finally, the trust beneficiaries do not have the protection of court supervision because it's a private trust, they're private. But if the trustee is breaching their fiduciary duties or doing anything of that nature, they always have the option of filing a petition with the court for issues that arise during the administration of the trust. So let's talk about what the revocable trust is an alternative to. So some people have durable powers of attorney, and I'm going to tell you that when I create a trust, I always create durable powers of attorney for health and for financial matters. I always create what's called a pour-over will, and I'll explain as I go through each of these why. So let's start with the durable power of attorney. That's basically a mechanism where the principal is the person creating the power of attorney, appoints an agent who's the person you're appointing to act in your place if you're unable to do so for yourself. And generally, when I do a trust and a power of attorney, I always name the successor trustees in your trust as agents on your durable power of attorney. The reason why is because you want the same people in charge of your money. You don't want to name someone else under a durable power of attorney and a different person as trustee and have there be a conflict. So that's the easiest way to avoid conflict. Now, there's certain items that you cannot transfer into the trust, and that's why a durable power of attorney is necessary. Retirement assets cannot be titled in the name of your trust. Social Security income, retirement income coming through cannot be titled in the name of the trust. They're in your name individually. So if someone needs to manage those assets on your behalf, that's why they're using a durable power of attorney. The problem with the durable power of attorney versus the trust is the durable power of attorney, although it continues during your incapacity, it terminates upon your death. So it doesn't allow for any administration after your death, whereas a trust will allow for administration after your death. The other thing is a durable power of attorney. The agent has a fiduciary obligation to act for your benefit, but those powers and requirements are not as broad and as encompassing as being a trustee. The trustee has more obligations than just an agent under a power of attorney. The other thing you need to understand is you could name someone as an agent on your power of attorney form, but they really don't have an obligation to act. They can refuse to act on your behalf, whereas a trustee cannot refuse to act on your behalf. They have to actually act and invest your assets for your benefit. Otherwise, they will be in breach of their duties as trustee. The other thing is an agent under a durable power of attorney does not have to account to the principal unless the principal demands an accounting or there's a court order. Whereas in a trust scenario, the trustee does have a duty to do an accounting on a regular basis. When you have a durable power of attorney, the assets remain titled in the principal's name. And the problem we encounter, quite frankly, is that banks and other financial institutions may refuse to accept our statutory form durable power of attorney. And they may say that we would have wanted the principal to execute our own form power of attorney. So if you have power of attorney forms, what I would recommend you do is inquire of your financial institutions if you don't have a trust and see if they have their own power of attorney forms and execute those just to be on the safe side. Whereas a trustee, once they take over as trustees, they go into the financial institutions, they will change title on the assets to their name as trustee of your trust. So that's the difference between the power of attorney and the trust. So the next item is a will. So the trust basically not only appoints a trustee, but it states how your assets will pass upon your death, just like a will. But the assets transferred into your trust during your lifetime avoid probate, whereas when you create a will, in order for the assets to pass to the beneficiaries under your will, they have to go through the probate process. So that's the beauty of having a trust versus a will. The other thing that's a good reason to have a trust is if you have a trustee, and let's say your trustee can't act or they've died, generally most trusts have an alternate trustee or successor trustees. I encourage my clients to name at least a couple alternate trustees. But let's say both people are deceased or can't act at your time, at the time you need them, whether you're incapacitated or deceased. Generally, there's language within the trust that states that there's a way to fill the vacancy in the office of trustee, and that could be by the beneficiaries all agreeing and nominating someone to act as the trustee. Or if there's no provision in the trust, you can always resort to the court, and someone can petition the court and ask for an order to appoint someone as trustee. The other thing about a trust versus a will and a probate is the trust generally waives a bond for the trustee. Usually in a probate, a bond may be required unless the will waives the bond or all the beneficiaries waive the bond. So the next item is the trust can be a substitute for beneficiary designation or transfer on death deed. So there's various ways you can transfer assets without having to go to probate. Joint tenancy deeds, if one of the joint tenants dies, it passes to the survivors. Pay on death beneficiary designations, those can be done on bank accounts and brokerage accounts. And California has a revocable transfer on death deed. The problem with those designations is generally there are not contingent beneficiaries. So if at the time of your death, the people you've designated have just died, then you're back into a probate situation. So you can create a trust and avoid all these complications because a trust can be tailored to create distributions that allow for most contingencies. So let's go into what the legal requirements of a trust are. Basically, a trust is created by a settlor, and the person can be married or it can be a single individual. And all you have to do is manifest an intent to create a trust. The trust has to be funded with assets, and the trust instrument must designate a beneficiary. In California, the trust cannot last longer than 21 years more than a life in being. That's called the rule against perpetuity. So what that means is that the people who are alive at the time of your death that are designated as beneficiaries, those beneficiaries, the last one of those beneficiaries to die that happened to be alive at the time of your death, the trust cannot last more than 21 years longer than that last beneficiary's life, because they want a way to make sure that trusts do not go on in perpetuity. And the trustee has all powers and duties as provided in the probate code, but the trust instrument itself can restrict the powers of the trustee. So you can tailor your trust to be very specific. I have clauses in my trust, and frequently I have some clients who say that, you know, they want to take some of these clauses out or they want to modify them, and you can tailor them to anything you want it to be. That's the beauty of having a trust. So a trust can be created by a declaration or an agreement. My trust say, you know, Helen and John Smith here, you know, hereby create the Helen and John Smith Trust and declare as follows. So it's a written agreement that states your intent that you're creating a trust. So let's talk about administration of a trust for a minute. So who administers the trust? Well, initially, when you're the creator of the trust, it's generally administered by the settlor. You will also be the trustee. So as long as the trust is treated as owned by the settlor, there's no fiduciary tax return required. And all the income is basically reported on your individual tax return. So there's no separate legal entity when you're acting as trustee of your own trust. It's just a mechanism to help avoid conservatorship, avoid probate on your death, and help out during incapacity. And as long as one of the settlors holding the power to revoke the trust is competent, no one else has a right to ask or request or make demand that you distribute or account to somebody else for assets in your own trust. So that's the beauty of the trust. It's basically set up as a mechanism for probate avoidance, conservatorship avoidance, and ease of administration, but no one else can make demands or disclosures or force you to turn over a copy of your trust to them. So what happens if you have a third-party trustee? Well, third-party trustee, the formalities have to be observed. So in other words, the third-party trustee has to come in, title everything in their name as trustee of the trust. They're bound to comply with the terms of the trust. They have a fiduciary obligation to follow the terms of the trust. Now, if you're competent and you're having a third-party trustee for whatever reason act as your trustee, you can make demands on that trustee and give them instructions on what you want to do. For example, someone else is acting as trustee, but you're competent, but you want them to make annual gifts to your children, you can make that demand as the settlor of the trust. If the trustee doesn't agree with what you're asking them to do or the instructions they're giving them, the trustee's remedy is to resign and permit another successor trustee to be appointed. So let's talk about a choice of trustee, because this, beyond who you're giving your assets to at the time of your death, your choice of trustee is probably one of the most important decisions you will make when creating a trust. I always tell my clients, you really need to think about someone not only that you can trust, who's capable, but more importantly, will follow your wishes. So I have some clients that want to choose the eldest child just because they're the eldest and they're worried about hurting people's feelings of the other children. Quite frankly, I always try to steer them towards picking a trustee that will follow their wishes and has some financial sophistication and sense, but they also need to be sensitive to the, the beneficiaries and what their concerns are, because it goes beyond just, paying bills and doling out the money, because there's, sometimes there's some delicate situations that need to be dealt with the beneficiaries, especially if not everybody gets along. And so you really have to be careful about your choice of trustee. I try to discourage co-trustees because a lot of financial institutions here in California, if you require both trustees acting together, they won't take the account. They don't want to be responsible for making sure they're both signatures on all checks and things of that nature. So it complicates things. If you don't have a family member that you can trust to do it, there's always professional fiduciaries out there that can do this job. There's financial institutions that have trust departments, although they're much more expensive, obviously, than having a family member do it. But quite frankly, more recently, I've had a lot of clients be more inclined to go with a third-party trustee. So let's talk about funding the assets into the trust. Now, if you're married, there are community property and possibly separate property assets. And if you're not in a community property state, then this isn't necessarily going to apply to you. But if you are in a community property state, the act of funding those assets into the trust does not automatically change the character of the assets you're transferring. Because under the family code, you're required to do an actual agreement in writing that states you intend to transmute those assets, the character of those assets, from separate property to community property. And the trust can include a statement that says that the character of the property isn't changed merely by funding these assets into your trust. I sometimes have clients that do have separate property and community property, and we create what we call here Schedule A to your trust, which sets forth the assets that they intend to be in the trust. And I can designate on that Schedule A community property assets and then separate property assets if they want to make sure that they're designated as such. The alternative is, if you don't like the idea of putting separate property into a joint trust, I also have clients who have created separate property trusts just for their separate property. And that trust deals with how that separate property is distributed upon death. And then any community property assets are created, a joint trust is created, and then community property assets are funded into that joint trust. So the next type of funding that creates an issue is joint tenancy property. Typically, husband and wife have owned their house as joint tenants, so that when they die, it passes by right of survivorship if they don't have an estate plan. But the idea of creating the trust is to fund the trust. And so what you want to do is fund your real estate, which is generally one of your most wealth, greatest wealth assets, into your trust. So you avoid probate when you die on that. If you both die together or the last of you dies and it's just titled in your name, it will cause a probate. So funding the joint tenancy property into the trust will terminate the joint tenancy. So after that, once the property is titled in the trust controls what happens to that particular asset. So during your lifetime, the trust will state what happens. The surviving spouse generally has the right to live in the house rent-free, and then it'll state what happens to your assets upon your death. So the other thing that's great about a revocable trust is that you can amend the trust. So the trust usually includes an express power to amend the trust, and sometimes, in most cases, it should describe the method by which you will be amending the trust. So when you create your trust, you'll be signing your trust twice. Once as settlor, which means you're the creator of the trust, and if you're the trustee, you sign accepting the trust as trustee. If there's a third party trustee and you still have capacity to make your amendments, you will sign the amendment as the settlor. The third party trustee must also sign the amendment accepting the amendment. So there's some other provisions that we put into trust documents. They're called spendthrift provisions. And basically, they restrain the ability to transfer a beneficiary's assets from the trust after it's become irrevocable. So it becomes irrevocable upon your death, upon the settlor's death. So when both settlors die or lose capacity at that point, actually it becomes irrevocable if you lose capacity, but then obviously if you don't lose capacity during your lifetime, it becomes irrevocable upon your death. The beneficiaries you name in your trust are now have an interest in the assets of the trust. Well, the creditors of the beneficiaries cannot, assuming you have this spendthrift provision in there, it prevents these creditors from forcing a transfer out of the trust for money judgments until those assets are due and payable to the beneficiary. So, for example, sometimes trusts can continue on until the beneficiaries, either over their lifetime or till they attain certain ages. And the provisions may say they're entitled to income only, but not principal during this time. You can draft all kinds of things into the trust. So the idea being is that if you have this spendthrift provision, it will prevent the creditors from coming and raiding their share of the assets of the trust. But a court could order a trustee to distribute for a money judgment only if those assets are due and payable to the beneficiary of the trust. So if the beneficiary is entitled to income, they can basically offset that judgment with the income or some of the principal that would be due and payable to the beneficiary. When the settlor is the beneficiary, on the other hand, so you're the creator of the trust, you're the settlor, it is not an asset protection vehicle. So your creditors can come and get to these assets for money judgments or debts you owe. The spendthrift provision only applies when the trust is irrevocable and it's basically sitting there for the benefit of your beneficiaries. It can't force distributions out unless those amounts are due and payable. So this is not an asset protection vehicle for the creator of the trust. So then we talk about no contest clauses, and everyone thinks this is just, no contest, I have it in there, so it basically prevents people from contesting the terms of the trust. Basically, a no contest clause is there to discourage a contest, but it does not prevent a contest of your trust document. So the no contest clause essentially states if you contest the trust and you lose, you forfeit your interest in the trust. So a contest can be a pleading filed by the court that triggers what's called the no contest clause. There are different ways of doing that. It could be a pleading. You could file an objection and trigger the no contest clause. You can file a cross complaint in a trust action and trigger it. Various things trigger no contest clauses. And so if you're a beneficiary and you're thinking about having something filed in court and you have an attorney, you better make sure that you discuss with your attorney, is this going to trigger the no contest clause, and make sure you don't violate those rules. Specifically in California, no contest clauses are enforceable only against 3 types of contest: a direct contest, a pleading challenging a transfer of property on the grounds the property was not the transfer's property, and a creditor's claim. So let's talk about a direct contest and what that is. Basically, it's where you file a pleading without, they consider probable cause, on the grounds that they're saying that the trust was forged, it wasn't properly executed, the person didn't have capacity at the time they signed the trust, they were under duress, or there was fraud or undue influence, or they could even claim the trust was previously revoked. So those are considered direct contests to the trust. Filing a pleading that says that that basically in the trust the settlor is giving away property that did not belong to them, so they didn't have a right to give it away. That could also be a contest, but in California, you have to specifically state in your no contest clause that filing this type of pleading is a contest. Filing a creditor's claim could be a contest, but once again, the no contest clause in your trust would need to state that filing a creditor's claim may be a contest. So what I'm trying to tell you is that no contest clauses do not always discourage litigation, because if you exclude an error, they have nothing to lose by filing the contest, because they would have not received anything under the terms of your trust anyway. So if someone files a contest and they win their cause of action, they prove one of these direct contest elements, then yes, there will be some allocation possibly to that individual based on how the outcome at trial goes. A lot of times people will file a contest in order to get into mediation and get the people, the true beneficiaries of the trust, to give them some money to go away, called shakedown. It happens. We see it happening. They have nothing to lose because they weren't given anything under the terms of the trust anyway. So some attorneys basically encourage people to try and maybe give someone some money that's significant enough that would deter them from contesting the trust and forfeiting the gift, but that's no guarantee either. What I find in dealing with clients is most people generally make equal distributions to their children or their beneficiaries. If there's going to be unequal distribution, I try to encourage them to have the conversation during the lifetime with their children as to why it's unequal, so the kids are put on notice, so it doesn't come as a complete surprise when they die and they see a copy of the trust and all of a sudden they're wondering, what happened. I also encourage my clients, if they are going to make unequal distributions, that they write a letter and give it to me for my file, explaining exactly why they're doing what they're doing, because if it ends up in litigation, I have something in their own handwriting, dated and signed by them, that explains what they were thinking. And the most important part of trust litigation is following the settlor's intent. And so that's very powerful if you end up having to go to some kind of contested hearing on your trust. So there's another term that we use in trust that always is confusing to people. It's called issue. So issue includes all your lineal descendants. So it means your children. And issue by right of representation means that assets will pass to your children, but if your children are deceased, then those assets pass to their children. The assets do not automatically pass to spouses of your children or spouses of your grandchildren. The only way that will happen, if you're using this terminology, would be if you specifically state in your trust document that you want these spouses to inherit. So you can define children any way you want. You can include children that are adopted as part of the definition of children. So the beauty of the trust is that you can define things the way you want them to be, and then the trustee has to follow your intent. So let's go on to providing for contingencies, because that's what a trust is all about. So you could have some minor beneficiaries, whether they be grandchildren or your own children at the time of your death, that end up with assets. So frequently I have my clients think about that, ask them, do you want the trust to be ongoing? If you have minor beneficiaries, they can have the trust carry on for years, 25, 30, 35, and they can get distributions over time, maybe half at 25, half at 30, and have it terminate at that point. The money could go in a custodial account as an alternative as well to maximum age of 25 here in California. So those are the type of contingencies you could provide for in your trust. All the trust documents need to provide, in case there's the death or incapacity of a child or other beneficiaries. I call it the what if. What if this happens? Chances are it's unlikely, but quite frankly, I have a couple who are almost in their 90s, and all three of their children have predeceased them. So you always have to come up with the what if this person isn't alive, where do the assets go? Sometimes I get clients in who have beneficiaries that have substance abuse problems. And so you can write language into your trust that requires that any distributions are going to be withheld by the trustee unless the beneficiary passes or has proof of a clean drug test. So those kinds of things can be written into the trust. You might have a beneficiary suffers from a mental disability. They can't manage their affairs. So the trust can provide that those distributions are going to be made solely at the discretion of the trustee, which means that the beneficiary cannot demand that assets be given to them. It's going to be completely discretionary. So you can also designate charities as beneficiaries in your trust, whether they're part of the primary beneficiaries or ultimately sometimes people name beneficiaries at the end saying, if everyone I name here dies before me, it's all going to these charities. And then you also may have some beneficiaries that may need to qualify for public benefits. And so the next topic I'll cover is the special needs provision. Every one of my trusts has a special needs provision. So those are provisions that are set up to preserve the assets for beneficiaries that are on public benefits. And the special needs provisions basically say that the trustee will only pay for things to supplement the needs of the beneficiaries. They can't supplant the public benefits. So they can't be used in place of the public benefits, or they will be disqualified from public benefits. So things like travel, entertainment, extra medical equipment, medical needs, the special needs trust can pay for. Public benefits, when I'm talking about public benefits, I'm talking about things like SSI and Medicaid. SSI is generally there for food, clothing, and shelter. And Medicaid obviously is there to pay for medical needs, or if the person can't afford themselves. So if there's things that aren't covered by Medicaid, certain medicines or equipment, the special needs trust can pay for that. It gets trickier with the SSI because you can't pay for food or shelter. Otherwise, it'll count against the public benefits, and they'll start reducing their public benefits. So you have to be very careful as a trustee when you're dealing with people with special needs. And the other item with regard to the special needs clause, it states that these distributions are solely at the discretion of the trustee. So the beneficiary cannot demand, so it will not impact their public benefits. So there are other discretionary distribution powers. Basically, the broadest power is reserved for the settlor. When you create your own trust, you can spend and use the money as you please. You can spend it all. You have no obligation to preserve these assets for the benefit of the beneficiaries of your trust. On the other hand, once you die, and if the trust continues on for the benefit of the beneficiaries, then there's ascertainable standards that are generally written into the trust that state that the trustee needs to use the money for the beneficiaries' health, education, maintenance, and support. But you can also put clauses in there that state that the trustee can look to other resources that the beneficiary has available, or their ability to earn income themselves, and take those things into consideration before they make distributions to that beneficiary. Finally, how do we terminate a trust? A trust gets terminated when all the assets are withdrawn or distributed. So you die, trust is administered. At some point, all the assets are either distributed or withdrawn. The trust terminates of its own accord at that point. For tax purposes, a final trust tax return is filed, and that terminates the trust with the tax authorities. During your lifetime, you can terminate a trust by actually revoking the trust and withdrawing all the assets. So sometimes that happens where people decide they don't want their trust anymore for whatever reason, or they want to create a different trust with somebody else. So we revoke the trust, they withdraw the assets, and then they figure out what other way of estate planning they want to manage their assets. So that is all I have to cover for today. It's important that if you start an estate plan but haven't completed it, try to get it completed. You can always make changes later because it's revocable and has an amendment clause. And it's a great tool to avoid probate, and it helps you if you become incapacitated during your lifetime. So I believe now we might be going to some question and answers.
Yes, Maria, thank you very, very much for that insightful information. Greatly appreciated, and makes us know what has to happen, obviously. A few questions here, Maria. One is it better to have an estate attorney prepare a trust, or is it sufficient to be able to do so yourself?
Well, there's a lot of online services. The problem being is that what I find when people come to me with these forms they've downloaded off the internet is there's clauses in there that may or may not apply, or may restrict them in some way, and they never intended, but they don't understand. So my recommendation would always be to have an estate planning attorney prepare your trust.
And kind of a follow-up to that is, does a will or a trust have to be notarized or filed with the courts, and where should it be kept?
So in California, there's no requirement that a trust be notarized. I can't speak to other states. In California, a will must be witnessed by two independent witnesses. That means two people who are not beneficiaries of the trust. So you can hand draft a will and date and sign it. A holographic will, that's what that's called, does not need to be witnessed. But if it's a form will, then there are requirements that you have to have witnesses. For a trust, we always notarize it just so we have proof that they had an independent notary that was there, saw the person, understood what they were signing. So that kind of gets you out to some degree under the no contest clause. If someone tries to say they lack capacity, quite frankly, if you have a notary there whose their job is to make sure the person understands what they're signing, that kind of defeats that. And as far as where you keep them, I don't keep my clients' original estate planning documents. So I either tell them to keep them in fireproof safes at home or in safe deposit boxes, and make sure that the successor trustees also have a copy of the will and the trust documents in case they need to, and you need to tell them where you keep the estate planning documents. That's a good one, because quite frankly, and I'm going to say I'm guilty of this. I put my estate plan away and then I forgot where I put it. So you have to put it away somewhere safe, but then remember where it is.
Well, you and I remember, Maria, we had a case where the trust was missing, if you recall, and that became a major issue. So, yeah, it's good to know where it is. Thank you. Here's a kind of a general question. How is an estate closed, and is there a time frame for an estate to be closed? Any specific requirements for closing an estate?
So a trust, there are no time requirements for closing a trust. By the terms of the trust, it can continue on for years. At some point, all the assets do need to be distributed, and if the trustee is unnecessarily delaying or withholding distribution, that's when you can resort to the court and force the trustee to be removed and get someone in there who's actually going to just administer the trust. An estate, on the other hand, the courts like to see the estates closed within a year. And if you can't close within a year, you have to file a report with the court explaining to them why the estate could not be closed in a timely manner. So when you're in a probate, the court is more on top of it, and there's more time constraints to get things administered quickly.
Someone asked if for beneficiaries on any kind of a legal document, bank accounts or retirement accounts, etc., do they have to pay federal and state taxes when that money is transferred to them?
So right now, each individual can pass $12,060,000 free of federal estate tax. California does not have an estate tax. Every other state, you'd have to check and see if there's an estate tax. So for federal purposes, as long as the assets passing are under that $12 million threshold, there is no estate tax due. But on the other hand, if you're inheriting like an IRA or an annuity, those are assets that have deferred income in them. And as those assets are distributed out of that vehicle, the deferred income is taxable income to the beneficiary.
Someone asked if they have for instance, if they have a second house that they'd like to leave to one of their children, how hard, he says, how hard or complicated would that be?
You would just write, assuming you want to do it through the vehicle of a trust, you would just make a specific bequest in the trust of that asset to that child. So it's not difficult in the context of a trust.
Okay. Someone's asking a question regarding a will versus trust, which you've already discussed, but they ask, how does a codicil work?
So a codicil is a codicil to a will, which means it's like an amendment. just like when you do amendments to your trust, most frequently people do amendments to a trust to change the trustee or change the beneficiaries. Codicil is the same thing, where you're just changing portions of your will, whether it's just to change the executor. Quite frankly, it's the same thing. It's like an amendment. So the original document remains in effect, and the codicil just changes portions of that will.
Very good, very good. Well, Maria, that's about all the time we have. We want to thank you again so very, very much for your excellent insights and suggestions. Of course, I want to also thank everyone who took the time to join us today, because they wanted to learn more about estate planning that could be used to extend their charitable giving to further empower the church's mission to serve the poor. As most of you know, Cross Catholic Outreach has developed a tremendous network of Catholic ministry partners around the world, and the dedicated priests, sisters, and lay people serving in the trenches are very worthy of that support. We pray that this webinar provided you with valuable information that will assure you that your estate planning will be handled with the care and expertise that you expect. For any additional information about any aspect of estate planning, please visit our Plan Giving website at crosscatholiclegacy.org, crosscatholiclegacy.org, or contact us by phone or email. The numbers are on the screen right now. My email is wfenton@crosscatholic.org, and my phone is 800-914-2420, extension 239. Your feedback is important as we plan future webinars that may be of interest to you. We'll be sending a short survey to all participants, and we would appreciate your taking a minute to complete the survey. May God bless you immensely, and thank everyone for joining us today.